beginning has to be with a willingness and a capability by national criminal justice systems to hold perpetrators of international crimes accountable. And I say perpetrators of international crimes because crimes of a gender nature, gender crimes in other words, do not occur in a vacuum. In the context of civil war, in the context of international conflicts, you find that mass atrocities are committed. And sexual violence, which is of course one of the gender crimes that we are speaking about, and other related gender crimes such as enslavement, forced pregnancy, and so on, that are committed within the context of conflict also occur in the context of commission of other international crimes. There are practical challenges and there are legal challenges. The practical challenges relate to the gravity and extent and nature of the crimes. In conflict, you find that there are mass atrocities. There are millions and millions of perpetrators. There are millions of victims. You will not find the victims in the place where the crimes are committed at the point at which you want to start investigating and prosecuting. Because they are forced to flee into exile. So they become refugees in neighboring states, and therefore they are not at the locus where the crimes were committed. So that's one practical problem. The numbers that present themselves of these crimes are they are enormous. So you have a situation where you have 6 million victims, individual victims as well as communal victims, community victims. And therefore that presents another practical problem. Another practical problem for accountability would be the non-existence of institutions, criminal justice institutions. So there are no courts, there is no prosecuting authority, the police force that will be required to investigate these crimes has been dissipated by the conflict. And so therefore it makes nonsense of assuming that somehow perpetrators can be held accountable in that kind of a context. So you have a breakdown of institutions, and where the institutions exist, then there is a lack of capacity. So those are real practical problems. The other broad area is the legal challenges, which are not unique, by the way, to societies in conflict or communities that are warring against each other. A lot of even member states of the Rome Statute have not yet domesticated the provisions of the statute to upgrade their own laws to ensure that investigations and prosecutions are carried out in accordance with international norms and standards. So localizing international norms and standards is a legal problem. Laws are still, in many countries, the laws are still archaic. They still do not have the advanced definitions, for example, of rape. They are still relying on old provisions of law that did not have the requirements around, testify, who can testify in a rape case and so on, where a lot of the laws had provisions that required corroboration, which of course has been done away with since the late 1990s and certainly on passing of the Rome Statute, on adoption of the Rome Statute. So those are legal kind of obstacles. The other area would relate to willingness, what some call political will to prosecute perpetrators, so that even where you have existing criminal justice institutions, you have prosecuting authorities, you do not have the will to prosecute, because most likely the armies or the militia or the people that are implicated in the commission of the crimes are still in power. So obviously there is no willingness to prosecute their own, even if they could. So a lack of willingness, a lack of political will to investigate and prosecute also remains a challenge. I think that court case, which was a civil case that was brought by survivors of post-election sexual violence, a number of them came together and they were able to bring a class action suit that asked for declarations from the court that the state had failed to protect them and that they were entitled as victims of sexual violence to such protection, and they were also entitled to reparations. Those were some of the issues that were considered in this case. It was important because they were able to bring this case as a collective. The Kenyan Constitution of 2010 allows for class action to be brought in our Kenyan courts, which is a significant advance because the Constitution also allows organizations to have what we call locus standi, to be able to bring suit on behalf of a class of victims. And I think the ruling of the court, which has not, to the best of my knowledge, been appealed and is being implemented, is that the victims were entitled to some form of compensation, and the declarations were actually issued by the court, which I think is significant, is really significant in terms of advancing accountability for gender crimes and certainly for victims. And I think the other important aspect of that case was it was a victim-centered initiative that says, yes, we suffered this violation, and the state that was supposed to protect us did not do so. And so therefore, it would probably bring a lot of policy reflection by the institutions that were implicated in that case, the police, I think the military, and the state itself, to do better. So in terms of significance, I think that's what that case did. I think the ICTR legacy matters, not just for the African continent, but globally. In 1998, this case expanded the definition of rape, put it out there. It expanded the definition of rape by including gender-neutral language. So whereas before one thought about rape in conflict or rape in domestic situations as happening just to women, the language that the judges came up with in the Akayesu judgment in 1998 was extremely significant in terms of expanding definition of rape. It also mattered because that judgment introduced a notion of coercion in situations of the commission of the crime of rape, which had not been in existence before. And that language was adopted in the elaboration of the Rome Statute for the International Criminal Court. So I think that's the significance of the legacy of the International Criminal Tribunal for Rwanda. I think a lot of the decisions that came out of the ICTR laid a basis for the advanced jurisprudence that we saw coming out of the ICTY, which is the International Criminal Tribunal for the former Yugoslavia, and the Special Court for Sierra Leone. So I think its legacy is established, and certainly what we, what I think everybody would want to see is, the precedents that were set in that court being utilized and being followed in national courts, which I think we haven't seen as much as we would have wanted to see, especially in our part of the world. Well, you know, a lot of these accountability mechanisms are provided for in the peace agreements that are reached in a lot of these contexts. Like, for example, in Sierra Leone, the Lome Peace Accord suggested the establishment of the Truth Commission and the establishment of the Special Court for Sierra Leone, which was a mixed tribunal. And it achieved quite some success in terms of being a court that was established in Sierra Leone, that was staffed by Sierra Leoneans and internationals, and that proceeded to try perpetrators of the most heinous crimes that were committed in Sierra Leone. Of course, it is the Special Court for Sierra Leone that tried Charles Taylor, the former Liberian president. And although he was tried at The Hague, it was the Special Court for Sierra Leone that actually conducted that trial. So I think in terms of establishment of these mechanisms, Sierra Leone could pass as a success story. The Truth Commission in Sierra Leone was also established, did enormous work. Its recommendations were implemented, including for reparations for sexual violence that had been committed during the civil war that lasted well over 11 years. For South Sudan, the peace agreement, the revitalized peace agreement, is being implemented. And in its raft of reforms that are proposed is the recommendations that are contained in Chapter 5 of the revitalized peace agreement that include the establishment of transitional justice mechanisms, the hybrid court for South Sudan, the Truth and Healing and Reconciliation Commission, and a reparations fund. This process is currently ongoing. As I understand it, a committee has been established to begin to look at the establishment of the Truth, Healing and Reconciliation Commission, and the hybrid courts establishment is under the purview of the Africa Union Commission. Having said that, there has been a conversation, not just in these areas, but also at the African Union around sequencing transitional justice measures. So, for example, in the conversation that resulted in the African Union Transitional Justice Framework, emphasis was laid on ensuring that peace is maintained, that a sustainable peace is possible, and that retributive justice must not be employed at the expense of ensuring that there is a kind of a sustainable peace. So whilst not saying that accountability measures such as courts were important, and in fact it is acknowledged that they're important, but there are also other measures which they called restorative justice measures that could be employed in context where there was civil war and mass atrocities. So it's not as clear-cut as let's establish a court and let us try all the perpetrators, because that is an impossibility. But let us look at it holistically and see, how to sequence the transitional justice measures that are being proposed even in this peace agreement, so that at the end we can attain that sustainable peace. So I think that's a conversation that has been ongoing at the Africa Union Commission level and in some of these countries where peace agreements are being implemented. Of course they are. So in terms of asking the question whether African courts or courts of African countries can handle international crimes, Yes, they can. I mean, part of the challenge, I think, has been the unwillingness of national courts to exercise their rights. It's actually their rights, especially if they're state parties of the international, of the Rome Statute. It is their responsibility, first and foremost, to exercise jurisdiction over their own citizens first. The International Court is a last resort. It was never intended to be a court of first resort. The courts of first resort are the national courts. So it is assumed that actually they are capable of handling crimes of an international nature. Our judges, our prosecutors, our lawyers, they are all trained in international law. It's not as if, it's nuclear science. It's something that they should be able to do. However, the willingness is what is lacking. In terms of independence, that's a related but a different question. Obviously, investigating international crimes requires resources. So we've seen that, part of the proposals that have been made is let's create international crimes division. There was such an attempt in Kenya. They have done it in Uganda, and so far I think they've tried one case, or they are in the trying one case. So resources have to be made available to these judiciaries, not just to ensure their own independence as an arm of government, but also to ensure that they are able to carry out the investigations necessary to try cases of this nature. And often, in context of internal armed conflict, there would be a lot of investigations that is required. There would be a lot of expertise that is required, forensics and all of that, cost money. So those are considerations when one thinks about creating international criminal divisions and so on. But certainly the capacity is there. Judy, I hate to disappoint you, but the future of international justice looks bleak. I said looks bleak because over the past few years, we have seen a widening of the impunity gap. A widening of the impunity gap and an increase of non-conventional armed conflict, okay? A widening of the impunity gap, a widening of the justice gap, and this has been documented, that in fact there are more people who have no access or less access to justice over the past 5 years than there was 10 years ago, for example. The widening of the impunity gap, despite or in spite of the establishment of the International Criminal Courts and all of these international mechanisms that are investigating violations of international humanitarian law and international human rights law. Right from Myanmar to Yemen, to South Sudan, Afghanistan, all of these proliferation of mechanisms that are investigating commission of violations of international humanitarian and human rights law. Yet the gap is widening. The ICC has had not the impact that we all thought it would have in terms of its deterrent value, including in countries that were situation countries. For example, in the DRC, we've seen what has happened in the Central African Republic. We have seen what is happening in Mali, in Guinea, in South Sudan. All of these conflicts have come about after the establishment of the ICC. And so therefore, there needs to be a recommitment at a practical level by states parties to these international instruments that create these international accountability mechanisms, to localize international norms and standards in their own countries. I think that's the missing link, and that is the link that we all have to work towards ensuring is made.